Hey, thanks for tuning in to Between the Lines podcast. I'm Alex Woods, a former ICU nurse and founder of U.S. Legal Nurse Consultants. This show uses medical legal cases to explore judgment, strategy, and decision making. But what we're really talking about is how people think when there isn't a clear answer. The stories come from medicine and law right now, but the patterns, the missteps, and the strategy, it applies everywhere. This is about reading between the lines and knowing what to do with what you find. So let's get into it. All right, Dan. So tell me about what first drew you into med mal and personal injury law.
So I do primarily personal injury. I do some med mal, but only if it's a bigger case. My dad's a doctor, my mom's a doctor, my brother's a doctor. So a part of me, I don't do it as a practice typically, but when a big case comes through, I'll take it on. But personal injury for me, I I started at the DA's office. I knew criminal law wasn't going to be for me long term. I worked in a great office up in Northern California, but I don't think anybody would ever describe me as a good soldier. I kind of always gone to my own rhythm, you know? And for me, working in the DA's office, especially, with all the politics and everything, the changeover in personnel from just how the sheriff's associations with the DA's office work and how all protocols come through, the marching orders, all of that. I just knew early on it wasn't going to be for me long term. So I got into personal injury because I had a mentor out the gate with my career, a guy named Roger Dreyer up in Sacramento. It's one of those big name guys.
Yeah.
And he took me under his wing and he said, Dan, you're gonna get to a point because I know you, and you're gonna get to a point where you're gonna find that you're not a soldier and that job is not for you. When that happens, come do civil litigation with me. So I went and tried a bunch of cases at the DA's office. I was trying as many as I could. Um, got the experience I needed, and for me, it was just that next step. Um, going into a prestigious law firm like Dryer Babbage, McCollwood, Camphor up in Sacramento. Um, that was a dream come true for me to be able to learn from guys like that and go into that world and really see what it's like to be in a business and start a business, be part of a firm. And that's really what drove me to it initially was the mentorship, really.
Yeah, that's a lot of people have, there's like a specific moment or case or experience that kind of solidified their path. So it's really cool that like a mentor is what solidified your path, especially someone who's done it before, kind of knew who you were and was like, you're not gonna like, staying in a box. And
Well, he and Dreyer knew this about me early on because I was the ADHD kid back in high school, and I went to school with his kids back in the day.
okay.
Like yeah, I've known him since I was a kid, pre-high school, and he always knew about me and what I was getting up to. And the thing he always told me is, Dan, this world was made for you. As a guy with ADHD and seeing how you work, he knew that if I got interested in something, and then made that a passion, that I would be an asset to him. And so,
Yeah.
he took that leap with me, and it kind of formed out the rest of my career. I think the only other point in time, my mom was once making a smoothie out in the kitchen, and the thing exploded on her, and that little ninja star in the middle came flying up, flew at her, and she batted it down with her hand and set her digital nerves across a couple of her fingers. And got her to the hospital, and I started talking to her at the hospital, and I was like, "We're gonna sue those guys." And so she would say that was the moment that she knew I was going to go in at least the lawyer direction, but maybe in the personal injury field. But if there was a pivotal moment that maybe shaped some of it out outside of, kind of the natural course of my career, I'd point to that.
Yeah, I think uh to piggyback off that, like you're you're just like some of your personal traits and your characteristics, like people who knew you were like, Dan, there's a specific field, there's a specific area where you're gonna fit just right in. So
Exactly.
that's really cool. That's really cool. So I was reading more about you on your website, and I saw that you had recovered and assisted in like over 50 million for
Mhm.
personal injury victims. Was Dryer one of those firms that you worked at primarily?
Yeah, yeah. So I started out at Dryers. My dad had heart surgery about 4.5 years of me working. Almost passed away, didn't, thank
Mm.
God. And it was kind of an eye-opening experience for me. And one, I had always wanted to start my own business. I always wanted to take risks. I really didn't want to look back in 10, 15 years ago. God, I had the stuff to do this and I just never made the jump because I was so comfortable. The money was great working at that first, firm, and but it just wasn't complete for me. I knew life was short. My wife had never left Sacramento. Um, she went to school at Davis. I met her when or ran back into her because we knew each other from high school. But I ran back into her when went to UC Davis Law. So it was like, we could live the rest of our lives here. Sacramento's an amazing town, but let's go and switch it up a little bit. Let's go live down in San Diego where my parents are and get as much time with them as possible and start a family down there. So we ended up doing that. And I started a business firm with a couple of guys from law school. And I hated business law for what it's worth. I mean, I think it's very interesting content material, but I absolutely hate billing. Tracking hours and just the time of tracking my billables, it just wasn't fulfillable for me or fulfilling for me.
Yeah.
So I wanted to get back to contingency work, and really with business law stuff, it kind of was like if you actually go to trial, and trial's always been my thing. That's the drive and the passion at the end of the day. So I realized pretty quickly that if anybody's going to trial on those business cases, it's either because, you know, somebody's being very stupid or somebody's an asshole.
Yes.
And I was like, yeah, I don't want my entire, life to fit around that. So, and your client could be either of those. You're not always, the conveyor or bringer of justice in those situations. It's just some of it's just counting dollars or counting pride. And so it wasn't really for me.
Yeah.
So I ended up joining up with a couple of buddies of mine that had also left Dryer Babbage. And I had more of a smaller caseload. I've always been a smaller volume guy, uh, just because I really like putting my entire being into each individual case. And at a certain point it becomes less practical, right? But I had some buddies of mine who had a higher volume practice, and we thought we'd complement each other very well. So we joined up together, and we did, together about 4.5 years, and I started having kids, and I just couldn't keep going up to Sacramento.
Yeah.
It's those
Yeah.
that lifestyle life kicks in, and I was like, I can't keep going up here 2, 3 times a month. The time was right for me personally, professionally, just to take the step and do it on my own. And so did that recently this last year, and we're off to the races.
That's awesome. So are you
Yeah.
trying to put your team in the courtroom more?
Yeah, yeah. Our goal is to get in the courtroom a couple times a year. To have some natural growth from that, some results from that. Just keep growing that presence. We were talking offline about Michael Alder and Kurt London and those guys, and
Yeah.
in terms of role models and seeing people grow practice around trial practice. As a guy who, and I don't want to age them, is about a decade or plus or minus, maybe a few more, but younger than them. Looking up to guys like them, what they've been able to accomplish through non-volume practice and being more trial oriented. It's inspirational for guys like me that want their career, fully based around that passion and practice. So that's definitely our marching orders in growing as a firm, and just getting back in that corner.
Yeah. Amazing. Dan, walk me through one of like the most complex cases that you've worked on. What made it challenging, whether it was legally, medically, or both?
Yeah. Well, man, we're talking about personal injury, so they can get pretty complex. In terms of medically complex, God, there's dozens at the. I mean, I've been through, over, God, now I've had over 750 clients, I think, at this point. So it's like there's always complexity to the medical portion, especially uh, in today's day and age where you're seeing head injuries and concussions and the science behind them really unfold before our eyes, right? This isn't some some piece of science that you can dust off a book and read about that's been the same for the last 30 years. It's always changing. So, head injury cases in general, they can be very complex. And I would say the same for, even spine injuries. When I was starting out and watching, even just, I've been practicing for about 12 years now, but looking back where I started to where it is now, seeing kind of the evolution of our understanding of spine injuries and spine treatment, you know, what the capabilities and the hindrances of diagnostic imaging can be. Those are, all complexities that we deal with in our practice day to day. But I would say in terms of the legal issues, you know, I've dealt with a lot of cases that dive into uh, course and scope, agency, mixed with, multiple plaintiffs involved. I don't want to name drop any specific cases right now, but, being able to handle the complexity of the legal issues involved and the factual issues to establish those legal issues and go through the ins and outs of law and motion, while also making sure you don't forget about the medical side of things,
Hmm.
which is obviously going to be the most important, not if not one of the most important portions of a trial. Uh, Being able to really take it from a deep intellectual standpoint of evaluating the evidence and comparing it to the standard of proof that you need to meet at trial. I think there's always complexity with that, right? Um, if you're asking me the most difficult situation to deal with, it's when I I, I tried a case with a guy who had a ruptured testicle. I caught a baseball in the groin and impacted his life very significantly, as you can imagine. And, having to deal with certain issues related to his relationship and, different problems that arose immediately leading up to trial, different people calling the police on each other 2 days before trial when we're ready to open. Those are very difficult situations to deal with as a young or as an old attorney. So, it covers the gamut. You see a lot in personal injury,
Yeah.
right? And I would say it all brings its own level of, personal, professional, mental health type of complexities that you got to learn to deal with.
Yeah, so many different personality types in that. And something you said about the imaging and dissecting, especially like clients with pre-existing conditions, that they see chiropractic care like monthly or they've been in another wreck before. I don't know if you've ever heard of PI Sciences, but they are a medical management service. Dr. Brandon Carter actually is one of the co-founders, and he is a chiropractor. And, he's been on the stand a ton of times, but he will look at the imaging and be able to prove, like, there was a significant exacerbation or aggravation of the spine condition after, post motor vehicle accident.
Wow.
Um, and
And I
so
haven't used them, but yeah,
yeah, I'll
gotta
I'll
check
send
them
you
out.
I'll send you a message. They're amazing. They'll do, like, their whole reports on it, and they've got, like, a big team of physicians, but they're really good. They work with quite a few attorneys. They're out and I always get this mixed up. I think it's Utah. But anyways, yeah,
I would say, and just to kind of like to cap that off, I think there's a difference between like complexity and kind of what your goals are in terms of presentation and putting it in a box for a jury to understand. I think that taking complex issues and boiling it down for a jury, using tools like the ones you just mentioned, I find that to be complex. It's targeted. It requires psychology, the presentation to the
yeah.
jury. I consider that complex, right? If I were to sit here and talk to you about every product case I've worked on, right? Those are complex cases in the sense that there's a lot of paperwork involved with them, right? They're very expensive. You have to deal with tons of different experts and hit tons of different points related to these issues and overcome a lot of different hurdles to get to a jury trial. It's complex in that sense, but the work's kind of the same at the end of the day. It's just more work, right? I think at the end of the day, the most complex thing we do is take these complicated issues, take complicated medical issues like the ones you're
Hmm.
describing, and boiling them down for a bunch of laypersons that, have never looked at, a netter's guide or wanted to look at anything that looks like a biology book, right? So people usually run away from that stuff if,
Yeah.
you know, if they're like most of us, right?
Yeah.
So I think that's where the real complexity comes in, and talking about those same guys we were talking about, like Michael Alder, Roger Dreyer, Kurt London, Hyperion, all these different names and big names in the world. Obviously Rowley, their ability to boil down these very complex concepts, especially in the world of brain injury, um, to provide that information to a jury in a way they understand, that is a very complex process.
Have you ever used like animation to help the juries? Like, have you? Yeah,
Oh
I
yeah,
only there's a one of the attorney calls that I did. He founded an animation video, and they're like, I don't know, like 50% cheaper than other animation.
yeah,
Uh, and I mean, they've won cases strictly because of the animation that they created because it was such
absolutely.
a complex issue. And so when you're explaining to the jury, talking to the, other attorneys, they're like, it really is how you present the case. You can have a claim that you think there's no way that this is going to trial. And
Sure.
then they're like the most obvious ones to you don't, and the jury doesn't buy it. And so there's, talking to Scott, he was just like, it really is about how you present the case.
And
And
when you see it for the first time, like how you can use those animations and their effectiveness, you get up in front of a jury and you say, "Oh, it was a disc herniation that was migrating into the L5 nerve root. And this is what it caused in terms of, peripheral or, you know, uh, neurological symptoms going into the legs." People are going to stare at you and go, "What the hell are you talking about?"
yeah,
Right?
yeah, yeah.
But you put up that animation showing that disc herniation going out, impinging on that specific nerve root, put up your dermatomes chart and show how that impacts other parts of the body. All of a sudden, 1 + 1 starts equaling 2 in people's
Hmm.
mind, right?
Hmm.
So
Yeah.
I think it's a
So
great point.
yeah. Dan, thinking of some of the cases, were there any like strategy shifts that you had to make, turning points or like key moments
Yeah,
of collaboration that stand out to you?
absolutely. I worked with a group of attorneys at a firm here in San Diego for about 9 months before I restarted my own firm. So I joined up with another group here in town, and great people, by the way, and run an incredible shop. They're very talented attorneys, and Paul and Dan are very, very business guys and are very client oriented. But they're also very, very good at hiring talented attorneys. So I don't impress that much. I don't get impressed that much. I think I've been in front of and have worked with the best in the industry. Uh, but seeing what some of the attorneys are doing at their office really made me think about stuff a little bit differently. And I probably was a couple of years late to the realization of simplicity and focus groups and really tailoring certain issues down to specific topics for a jury. I've always been about theme and theory, but the way that, some that specific like Taylor Gaines over in Bata Fulkerson, he really turned me on to a more progressive way of thinking about presenting to a jury. He came from the PD's office. He's done over 50 jury trials in the criminal side, and he's on an absolute tear on the civil side. But seeing how I was very mathematical and logical, and I would even say, in hindsight, a little stiff in terms of how I would prepare the case for trial. I Taylor put me onto this way of really having more of a progressive look at how the case law can directly impact the way you're presenting evidence to the jury, both in terms of Sanchez and taking treater depositions and using them in lieu of like trial testimony, adding more tools to the tool set. You always got to be learning, but seeing him do a couple of these more progressive things that frankly people weren't doing 10 years ago, um, which is where my primary training really came from. Kind of, it really showed me that there's a more progressive and modern way to try these cases in terms of the use of focus groups. I was never really a huge focus group guy. Taylor's obsessed with them, and Michaela is too. And seeing Michaela and Taylor work together on some of these cases and using some of these newer tools really allowed me to go, wow, I can present the evidence in a much different way, a more personal way and connective way to this jury, because you're almost trying the case in a number of different ways before it's actually being tried. So if you were to go, what was the actual transition, Dan? I think it was more, I was very focused on the trial itself. I used to be very much like, here's how I'm organizing the evidence. Here's how I'm organizing my exhibits. I got my exact theme and theory dialed, and I'm not deviating from it throughout, my expert depositions, through my motions, through the trial presentation. Um, Seeing how they were able to test all these things before you ever stepped in the courtroom, and then take the right sample from that testing to present to the jury, and its effectiveness, it's just a whole different level of trial work. So, I think you'd probably expect me to get up here and say, one of these higher echelon guys, the gods of trial practice, were the ones that teach me something. But, really it was my peers, people in, very similar, same age group as me in terms of, attorney age, that really, it's really changed the way I'm trying cases now.
Yeah, I love that. I love how you said how you've learned so much from your peers, because I'm the same way. And in any career, collaboration is key. And really the goal, like, especially Dan, we talk about entrepreneurship, and we really love that topic, especially in the beginning. But part of being like the best leader and the best attorney is putting the best people or better people in the room. And so, like with Taylor and peers, that are doing these focus groups and giving like other opportunities, like to try a case in a different way, it's just like this. That's how you get better. It's how you get better. It's how you mentor better. It's how you attract better attorneys. So, that's awesome.
And
It's
it's issue testing, you used to be so for like, you're always talking about the medicine, and you're talking about, the presentation of facts related to liability. But what some of these new tools can do is show you where the pressure points, or, frankly, the anger points are for a jury. And you can reorganize your evidence and your presentation to accentuate and really emphasize the unreasonableness of the other side in relation to these issues, that really, when you're a trial attorney and you've been working on these things for 2-3 years, and you're invested in your client, invested in your case, sure, everything becomes important, but being able to really narrow it down to things that actually matter to a group of people that otherwise don't care about you, the case, the judge, your client, being able to actually see what they actually care about beforehand, it just cuts through so much BS at trial. And it's been really helpful to see it that way. I hope that makes sense,
yeah,
like the
yeah,
difference.
yeah,
I don't want to make it sound like when I was trying cases before, it's like this hodgepodge of evidence I'm throwing out there. That's not what I'm talking about. It was just more of a very structured process built around the whole body of evidence, and what, the use of these focus groups, and taking, for like, again, taking expert depots in lieu of live trial testimony, and being able to use the evidence code and case law to your benefit in terms of what evidence comes in versus doesn't, for very good reasons, and structuring your whole case around that. It adds another layer to the trial preparation and presentation, that, just, you can still be effective in both ways. But I enjoy the more progressive way, and I like going into trial now going, okay, I'm not guessing at what people are actually going to care about. Now I have, data driven results that are telling me what I should be telling them about at trial. And
yeah.
it's just a way to try the case.
since doing these focus groups, have you, by data, objectively speaking, have you noticed an increase in your wins?
Yeah, and I mean, from settlement value to case resolutions, and the ones I've been privy to with colleagues as well, and seeing kind of how they've built them up and utilized them, um, provide for a number of different reasons, both strategically and just in terms of presentation wise, they're a complete asset. Like, I
Mm,
mean, and they're less expensive than they used to be. And there's companies out there like Jury Analyst, for example, that give you different options, kind of a la carte options in terms of how you want to conduct a focus group. Um, you know, we're talking about spending 8 or 9 grand against an investment of 150 grand at trial. It's a no brainer, especially when you're going to get just these beautiful morsels out of it that you're going to be able to spoon feed to a jury. I mean, it
mhm.
makes all the difference. So I'm never going back.
Yeah.
Yeah.
Yeah, if it's working, keep going with it. Um,
Yeah.
so Dan, I
And it,
often hear,
and it absolutely increases the value of cases
yeah,
because you can do so much with these reports too. So,
yeah. Oh, that's awesome. Dan, so I often hear that failure is our greatest teacher. We have a bunch of failures, mistakes. What was one of your biggest mistakes, or let me take that back. What was one of your most pivotal moments in trial experience that changed how you approached cases?
well, just what staying on the theme we've been talking about, it's simplification, and I think for any real trial attorney out there, they're going to go, yeah, duh, Dan. But, I tried a case 2 years ago, solved case involving third party culpability, third party conduct, security case at a hotel. And it was a gross negligence case. We couldn't, prevail just on negligence because there's signed waivers involved. So we had to prove gross negligence. And at the time, this is what happened right at the beginning of COVID. And I went into it going, you know, we need to show everything these guys didn't do. Right. And I remember talking to the team that I brought on to try it with me, like all of these things they did not do that evening were egregious. Like this is stuff where they're holding out that they're going to do certain things and they just weren't doing it. So my tactical approach on this case was to list them all out, and I went up and I listed out 20 different things that based on, the testimony we'd received in litigation up to that point, what had come out at trial. Um, every one of these things we listed on page and said, this is gross negligence. This shows like not even a scant of care about what's happening to people that are still on this property. And I realized after the fact, and I took an L on this case, on the gross negligence issue. Uh, I looked at it after, and I've had lots of time to think about it because you pour everything into these cases, and taking a loss, especially when your client's been through something like what she went through in this case, it hurts. It hurts bad. So you're looking back and going, what did I do wrong? How could I done something better? And I think if there was something I would change looking back is I would have picked maybe two, three things they didn't do and focus the jury entirely on that rather than provided the complete list of things they didn't do. You can pop those things in, as supplemental points during exams, but overplaying your hand almost, and I think any trial attorney out there that's lost a case, which any real trial attorney has lost a case, but they would probably think the same thing, which is, you're always in retrospect again, find the solution, right? It could be true, it could not be true, but I would just put two or three things out there. You would emphasize two or three points because when you provide a laundry list of things, I don't want to use desperate as the word, but it comes off as you know, hey, like who cares? The items 1 through 5 seem very important, sure, but this other garbage you put up is 5 through 20. You know, that makes me think that you're not too confident that 1 through 5 actually reaches this level, right? And so thinking about it under that light, I look back on like that case and go, my mantra about trying cases and setting up cases for trial now is simplification.
Mm.
Simple, simple, simple. Keep keep the sample size small, keep the points short, and make them with confidence, right?
Why do you think the jury didn't take all 10?
And maybe they
Do
did.
you think it's a like going into before you started trying cases and then when you started trying cases, did you notice like there's a lot more psychological part element to trying cases than you ever thought?
Absolutely. And I think all the science and data we've collected from how jurors evaluate cases reflect that you should focus on a small sample size, you know.
Mm. Hmm.
And if you're not focusing on a small sample size, uh, eh, there's ways to link all of those other external, factual points into that small sample size.
Yeah.
And you got to be creative. That's the whole point of being a trial attorney is find a creative way to accomplish that. But, thinking that you can get up and just list out the facts and then argue, look at all of these things they didn't do, and that the jury's going to really in their mind, right, go, okay, I see all of these different points. This equals the result that this guy is looking for. I don't think that's how their minds work, right? It is, what are we going back in deliberation and what is really sticking in my mind? Not the 20 things, but the three things,
Yeah.
right? Science fully backs that statement, right? Like the average attention span, it can recall three things exponentially better than 10 things,
Hmm.
right? So carrying those types of psychological points into trial practice, I think it comes with experience and age, watching a lot of trials, and maybe having a couple of bad beats and hard losses. Um, it's part of the evolution of somebody professionally learning that stuff. But um, and I knew that going into these trials, this one I just really wanted to show everything these guys didn't do. Um, but I think it just reminded me, hey, in every trial prep moving forward, it's consolidate, consolidate, consolidate. Find your three things. Find your three things because the rest will be discarded more times than not. Yeah.
Yeah. Yeah. That simplification, that I think that's going to hit home for a lot of people. In your experience, Dan, I know this isn't one of the questions, but it came to mind. In your experience, what's the most overlooked factor that can completely change the trajectory of a personal injury case?
The defense taking an unreasonable position. If you are able to corner a defense counsel into taking an unreasonable position, it is by and large the most effective tool at improving your odds of winning a jury trial because they'll hang on. They choose people they like and dislike, and they're sitting there the whole time going, why the heck are we here? If you can get a point across to the jury to that, so when they're back in deliberation going, oh, we know why we're here. It's because these guys are taking this stupid position, whether it be on, liability, causation, or damages. It can be on any of those issues. Uh, I think the most effective is when they take an unreasonable position on liability. But if they give you that gift, you need to embrace it. You know, don't don't force them to change their position. Let them take that into trial. If they're unreasonably saying, "Hey, he wasn't in the course and scope here," well, that's what your jury trial is going to be about. It's not going to be about your guy asking for a future knee replacement or a future fusion. It's going to be about whether or not this person was in the course and scope of their employment. And if they go with you on that issue, they're going to go with you more times than not on the rest. Um, so I think really being able to define and pinpoint and make sure that the unreasonable position on a given issue is preserved through trial is probably the most important thing you can
Yeah.
do to increase value and improve your chances.
Yeah. Nailed that one. The topic of this mini series is like the legal edge. What's something you or your firm have done that's elevated your practice or given edge, whether that could be strategy like focus groups, AI integration, something that's helped your practice become more effective, connect with juries better, or just serve your clients more powerfully?
I use a company called Law Firm Architect to help outline and blueprint all of our processes in the firm from case inception to conclusion. Being able to because we know we can practice law, we know we can run a business, but being able to create the culture around a firm, I think is the most important part. Getting people into the office that care about what they're doing, understand why they're doing it, and being able to remove as many mundane pieces of their day as possible. It creates a culture, and it creates a culture, in my opinion, of excellence, which is what you always want to pursue in litigation. So for us, especially using like this company, Law Firm Architect, probably the best consultants I've ever used. Um, we've been able to really outline what our practice looks like and been able to specifically pinpoint what parts of that practice can be replaced with automatic processes or AI versus, having somebody manually do it. And some of these are very mundane tasks, right? So being able to push people to do what we're here to do the actual practice of law versus where do I put this cost? How do I organize this cost? Where do I file this document? How do I name it? Those types of things I think are the core of what can push you and your people to the top of the practice. So that's really what we've been concentrating on. And it's going to instruct us from new hires, all the way to how we practice and try cases.
Yeah, a couple things that you said there. Culture is so important, like, as a business owner, because you wanna hire people like, the right people, and I've noticed lately in the last year that a lot of law firm owners, they say, "I don't care what your resume says. I wanna know if you care about our clients, if you work well as a team, and they have certain characteristics that fit, like, the type of people that you wanna work with." When you hire someone, do you go through obviously, you go through interviews, but how heavy does a resume lie, when hiring people?
For me, and maybe it's an unpopular opinion, I've always been a, a big advocate for grammar and English and the use
Yeah.
of the English language. So if I see typos in a resume, if I see, issues in terms of sentence structure or whatever, uh, those will get nixed.
Mhm.
And for better
Well, I
or
think that's a
worse.
level of professionalism too, like, come on,
Yeah,
like,
and I
you know
think it dictates a lot, and
yeah.
right or wrong, because I think, like, for example, my number two Tiara, I I I got her and was blessed with her, thank God, but through very unconventional hiring structure at the time, and she's been with me for 4 or 5 years, but she's probably the most talented paralegal I've ever run into, and we've built a culture of working together, and the people we bring in to work with us, that's very specific. I don't remember her resume, and I remember like I said, the way we went about hiring her at the time was unconventional, and if I were to redo it again, I would, because I don't think I was the prototype of a good hiring attorney at the time. It was like, I need somebody in the door and I need them to do this, right? So I think I mean, it's a two-way street, right? Just like expectations from people, having good resumes, getting it on one page, having an environment for them to immediately be able to come into and contribute and getting fulfillment from is equally important, right?
Mhm.
So finding that sweet spot between the two, I think, is the real trick. I don't think it's just resume. I don't think it's just references. It's what is their storyline? What's their performance? Who do they have around them in terms of people and life structure? I think all these things matter, right?
Yeah, and not only that, I think, people want to be seen, and they wanna feel like they matter and like they make an impact. Like, dollar amount is great, that's one thing, but if you're, like, not recognized and not seen as a big part of moving the needle, then a lot of people will just kind of be like, "Well, I wanna feel, like I matter somewhere else." So,
Totally.
you know?
Yeah.
And I want to add one more thing about like just being an entrepreneur and a business owner is, you mentioned integrating different tools and companies, law firm architect to better your law firm. Do you feel like law school taught you anything about, that?
Zero. Oh God. I mean, I've always wondered, like looking back, I always wondered if I should have done a slash MBA, the JD MBA. I'm glad I didn't at the end because I've been able to organically kind of accumulate some of that MBA-ish knowledge along the way. And I think just kind of figuring it out as you go and as you go through different experiences has been valuable to me so far in my career and professional life. But um, they really need to figure this out in law schools because they don't prepare you at all for it, right?
Do you think
I
that's
think, and then
purposefully?
no, well, I think to a degree, just like anything with any type of process, procedure, or government grants gets you. I think there's a large population of law schools that are they just are focused on making sure people have jobs at the end of it.
Mm.
There's another section which is, hey, these people are going to go into public service. And then there's the big law, right? Big law, king up on top, right? And then the other two come after that. So I know schools have a lot of different specialties, but if you're going into public service and that's what your school specializes in, why are they going to contribute funding to, you know, those who want to go and do solo or private practice, right?
Hmm.
If you're going to have somebody who's going to big law, are you training people to go and create businesses within those businesses? Not typically. You're working for big corporations, and it's all about the billable hour and do the elite work and get wins, get more big clients, right? So there's stuff out there that I think complements all these objectives, like how to build a book of business. They just say, hey, go out and network and meet some other mentors and they'll introduce you to people. That's about the extent of it, right?
Yeah.
But nobody actually says, hey, here's a tool you can use as a book of business from day one. You should start an Excel spreadsheet that is built a certain way. And you are listing every certain single person that goes in there and you're collecting business cards. Hey, you can use Evernote to use your phone to just gloss over that thing and it'll auto organize it into your Evernote and put it into your Excel spreadsheet. I think those would be very effective things to teach teach, to be professionals in law school, but they don't, right?
Hmm.
For whatever reason. It's very aggravating because those
Yeah.
types of things, Alex, that, starting a business of your own is once you learn those initial concepts and the in practice implementation of those concepts, they compound into totally different things that you create yourself,
Yeah.
right? So you add additional tools, you add additional pieces, new processes throughout your professional or networking life. They give us no framework to do that outside of
Yeah.
just go out and see if somebody remembers your name when you pass the bar. I don't think that's effective, right?
Yeah.
So should they have a class on that? They should. Should they teach us about AI tools? They should. Should this be integrated now versus later? They should. You
Yeah.
know,
I think the
it's
same in high school. A lot of high school, in my high school, they didn't teach us taxes. They didn't teach us well, there was one class how to write a check, but
oh, this is one
I
of the books I want to write. It's called The Book of Adult Shit.
you should. And
and it's
I hope in a
how
couple
to buy
years I
your
see.
first house, how to get a mortgage, how to pay your taxes, right? How to set up a dentist appointment.
There's so many books and podcasts and entrepreneurs that have so much information, but you're kind of like, who's right? Like, I
Yeah.
just want to know I want to know the basics.
Yeah.
As an ICU nurse, if I have patients or colleagues or friends and they say, Alex, something happened to me, who do I go to? Who should I call? Why choose your firm? And where can they learn more about you if they'd like to connect?
Yeah. And I mean, I'll tell you what I tell all my clients. I have three jobs basically. It's to create options, create leverage. Those two things fail to tell a story to a jury. Our practice is based around trial practice. I'm very upfront and frank with my clients about how I talk about cases are always going to be under the lens of trying a case or arbitrating the case. Um, that's how we create leverage, how we create value, and we're very skilled at it. We've been able to do that for a long time now and get the results of our clients that I think speak for themselves. So um, we're not a volume practice. We really put every single case under the microscope. You're always going to get me or one of my attorneys looking at your case specifically, and it's not about volume. It's about making sure that we're taking each case individually and getting full value for the injuries that they sustain.
Awesome. All right, Dan. So if people wanted to learn more about you, your firm, how do they connect with you? Website,
Yeah.
LinkedIn? Do you have any other social media?
Well, I'm obsessed. I'm obsessed with LinkedIn, so you can always follow me on LinkedIn or track my stuff on LinkedIn. My firm's name is Schneiderman Trial Attorneys, trialteam.com. My kitschy title is Your Future, Our Fight, Your Team. All our branding and everything's based around trialteam.com.
That's awesome. Well, Dan, this was great. I had such a good time. Hey, if this episode changed the way you think or gave words to something that you already practice, subscribe so you don't miss what's next. And if you know someone who makes high stake decisions, maybe solves complex problems and works in gray areas, send this episode their way. Between the Lines is for people who care about how judgment actually works. We'll see you on the next one.